A very warm welcome to one and all present here in lecture series titled Basics of Criminal Justice System organized by Aiding Hands Foundation. Now I would like to welcome our esteemed speaker Mr. D.P. Singh, Senior Partner, Bharucha and Partner. Now without wasting any further time, I would like to hand over it to sir. So over to you, sir.
Hi, welcome everybody. And pardon me, we have taken a big gap between our last lectures and today. And also, this is primarily because, uh, you know, there were some engagements and then there were technical issues because of the ongoing pandemic, and we could not do it. Now, in our journey on basics of criminal law, we have we have discussed about from registration of FIR to going through the investigating process, the issuance of various things, a little bit of almost everything that one should know has been done before the trial is to be over. We have talked about charges, charge sheets, investigation, how it is done, the importance of the statements, and everything. And we are right now at the doorstep of a trial. Now, there's a I had requested that if I can be told whether we would like to go with a violent crime or a white collar crime, because we have gone through all in last so many years, and it would have been easier for me to then pick up one if I would have had some request. But now that there is none, and also I want to wrap up today because of the ongoing situation. I don't want to take three lectures as it was contemplated. So we might take a little longish session today. No matter what, we will not be able to, comprehend in totality a criminal trial, one, on a platform like this, and two, in one, two, or even three sessions it would have barely touched with the nitty-gritties of a criminal trial. Now, since we are going to do only one session, long session, I thought, how do we go about it? So I picked up a trial which was closer to my heart, which happened to be my first trial and which is always closer to your heart. And I've lived a journey, a long journey of a lawyer with this case. It started from a sessions court. I'll tell you what. It started from a sessions court and it ended up in Supreme Court. It's a reported case of 2014, and the citation of that is Jumni and others versus State of Haryana, 2014 11 SCC, page 355. Now, the journey of this case started way back in 1990s. I was a young lawyer, had just started my practice, and I was approached while I was practicing in Delhi and Chandigarh High Court for a bail application. Now, the charges in this case were 302, 304B, and essentially depended on a dying declaration of a woman. And the accused in this case were the father-in-law, mother-in-law, three brothers-in-law, and one sister-in-law. Out of them, they were poor people living in a village, except for one man who was a fitter in Hindustan HMT factory in Pinjore, Hindustan Machine Tools, as they say. And he was working in Pinjore while the incident happened in Yamuna, a village near Jagadri. Jagadri is the old town of Yamunanagar. They are twin cities. So Jagadri, near Jagadri was the village where the incident took place. A woman allegedly was brought to the hospital and she gave a dying declaration to a magistrate first class, and the doctor allegedly had given a fitness certificate, and the fitness was also recorded by the magistrate first class, and that statement, on that basis, on that statement, FIR was recorded. So I was approached in High Court for a bail application for these people because everybody was taken in custody and they were behind bars for at least 2 to 3 years. So I applied for bail thinking that it is a clear case for two people for which I wanted to apply first. And thereafter, I wanted to apply for old couple, that is father-in-law and mother-in-law. But I hit the wall in the first case itself, which was with regard to this brother-in-law and sister-in-law of the deceased, who were working in Pinjore and were staying in Pinjore. The bail was dismissed, saying that this is 304B. Young woman has died, and therefore the court should show no sympathy. I worked really hard on this case. As such, when you are young and you get your cases which are far and far in between, you're working with a senior and yet you get a case and you want to give your 500% to it. So these were clients who gave me 2,000 rupees, which was a princely sum for them. And in those 2,000 rupees, I realized as I was talking to them, I was with them, that too was given by somebody else because there was absolutely no money with the entire family. Forget 2,000. On their own, they could not even give 1,000 rupees, all combined together. I also came to know that the children of these clients, that is the three children of uh, this man who was working in HMT factory, his name was Premnath. His wife was Rajbala. Their children had nobody to take care of. And the smallest child was actually, not taken care of and it was a mental wreck. The eldest was a daughter who was molested and also was going through a depressive disorder. And the third child who was going to school was also not going to school because there was nobody who could have sent him to the school. They were crying. I could not do much. I offered them that if you want, I can do a trial in the sessions court at Jagadri. They said that they have no money to give because whatever money and some amount of about 10,000-11,000 was taken by the local lawyer who was there, and that was collected, and there is absolutely no money that they can give. But they would be pleased if I can go and do their case there. So I decided that I'll do this case free of cost. And I used to drive down to Jagadri to do this case. The charges had already been framed, some prosecution witnesses had already been done, and I realized that the trial court lawyer had done some job, but perhaps not to its optimum. Now was the time when only the uh, investigating officer was to be examined, and the local lawyer was of the confirmed view that they don't want to lead any defense evidence. I disagreed with him. I said, without defense evidence and whatever evidence available to them, we cannot defend the case. He got angry. He was a senior counsel of the bar. He said this youngster is going to demolish, is going to be singularly responsible for anything untoward if it happens in the trial. So it was to the clients who were the relatives of these people, because everybody else was behind bars. And the husband of the deceased was uncertain and really not concerned whether the case reaches a conclusion or not. And in this scenario, they decided that I must go ahead with whatever I want to. So in this background, I started doing this trial. And since this was my first trial, I had no idea how to go about things in the trial court. I started my practice in High Court, which was a mistake. If you want to be a criminal lawyer, you must start your practice in the trial court. But nevertheless, it was my first trial, and my first trial had happened to be the murder trial in a very difficult case. So whatever I could learn myself, discuss with my senior, discuss with whosoever was ready to listen to me, it was something that I would hear, read, and read again and again, because I recalled those lessons that read your FIR 100 times. And I actually read it 100 times or more, but not less. I used to read the evidence, the 161 statement again and again and again. I had read and underlined the charge sheet so many times that it started tearing. And yet I could not convince myself as to what I was doing. And I want to share all these things because everybody shares their victories. But this case was a mission for me. It was not a case anymore. So in this case, finally, I was left only to cross-examine the IO. I cross-examined the IO and I did an awful job. I could not get anything from the IO. On the contrary, I ended up asking questions which went against me. The local lawyer was quick to pounce on that and told my clients that you are in the hands of a person who will doom you, them. But I don't know why. Maybe because of my passion or because the way I was working hard on the case. I used to go with a bag full of cases, books, and other things, and pure perhaps energy with which and conviction with which I was fighting the case. I had no clerk, Nobody. I used to drive myself, carry my bag to the court, and yet I was a lawyer from High Court, and the local bar would assemble to listen to me. And when I made a fool of myself by asking a few wrong questions, there was some people who gave it up on me. But some youngsters, maybe because of my energy and how I used to passionately argue with the judge, used to start. They started coming and watch me. Now was the turn of 313, and then thereafter the turn of defense evidence. I'll give you a black this thing, and then I'll give you a little bit of trial also. And in the trial, I selected 7 witnesses for my defense. Again, there was a big furor because usually in those days, one would take their defense in the 313 and avoid leading evidence in defense. One, it was difficult. Two, there was a risk of further proving your case because at the end of the day, in the mind of the trial lawyer, it is always that he has to only put a suspicion in the mind of the court, which according to law is correct. But then it doesn't work out that way. Sometime when especially there is a dying declaration, especially when there is a case where a young girl had died within a year of her marriage, the equities are not in your favor. And all you have is that the dying declaration is wrong. At least I was sure it was wrong with regard to 2. That is Premnath and Rajubala, who were there in Pinjore. If they were not there, then the dying declaration was certainly not correct. So my challenge was to prove my plea of alibi. Now, if you really do your research, rarely does the plea of alibi succeed. So I had taken a defense which was most difficult, where the entire onus was on me, and prosecution had to only have a doubt, create a doubt. So in my first case, I was treating on the most difficult defense, and I selected 7 witnesses for that. Now, 7 witnesses, out of those 7 witnesses, 5 were the colleagues of Premnath who were to prove, who were or also their neighbors or working with him in the factory, and including the punch they used to do in the factory for going in and for going out. And there was a problem there also, that there was no punch of entry or exit on one of the 2 days, which I was trying to show that he was not in Jagadri, but he was very much in Pinjore working in the factory. On the second day, he had also gone to purchase a scooter for himself. And we had all receipts, and those were the other 2 witnesses. So in these 7 witnesses, I was sure that none of them can be, doubted. Lo and behold, I called 7 witnesses, and they were examined on 3 different dates. They came, they asked me, do we have to say something? I said, you have to say the truth. Was this man there? They said, yes. I said, then I need to ask these questions and the prosecution will cross-examine you. I did not, tutor any of the witnesses to say a particular thing. I say the truth. Also, sometimes when you are fresh, I had no idea how to tutor a witness. So since I did not know, I went with my gut. I went with truth. The trial did the witnesses were done, cross-examined, and then the case was argued. And I argued that case in a sessions court for good 4 days, which people thought, how is the judge indulging and why it happened? And many times he wanted to stop me, and I said, no, I have to show judgments. I have to read this. I have to read other things. I forced him to listen to me for 4 days because I was convinced that he is not convinced. And he wanted a shortcut that this is a dying declaration, this is 304B, and therefore they need to be convicted. He had made himself clear on the first day, or rather, even before we had started arguing. But I kept my composure. I argued for 4 days, but we did not succeed. He sentenced them, all of them, to life imprisonment. Then came the appeal. I filed the appeal in court. One man died. And he died. I remember one of my favorite judges who heard this bail application and appeal. I had a huge respect for him. I said, my lord, he is going to die. He is suffering from this. Since he was a bright judge, he said, no, no, these are common ailments. Even I have it. Nobody dies. But third day, he died. I went to the chambers of the judge and said, Judge, he died. I must say, the judge was perturbed. But then there's little he could have done. Then I came to Supreme Court. I had by that time spent some time. I had become additional advocate general. The case had not come for hearing. When it came for hearing, I was practicing in Delhi. That too for the state of Haryana itself. I was additional advocate general, so couldn't have gone and argued the case. So I asked a very senior lawyer, Mr. R.S. Chima, who was my guru and whom I consider the best criminal lawyer ever, along with Mr. Ram Jethmalani. He argued the case. Again, he could not convince the division bench. And then it came here. The case was admitted. It was the first sigh of relief. In 2014, it came up for hearing. And it came up for hearing before a very, very difficult judge. And meanwhile, one more person in that case, called Balbir Prasad, the son of Ratiram, who had died, also died. None of them had been granted bail. And then the matter was heard before a very difficult bench of Justice uh, Madan Lokur and Srimati Ranjana Prakash, Justice Ranjana. We still went confident. This case was argued over 2 days in Supreme Court. And the judge accepted our plea of alibi. And the case was acquitted precisely on those 7 witnesses. It was a clear acquittal for 2, and benefit of doubt was given to all others. And it was acquittal. Now, one would say that should have been happy, but I cried that day. I get emotional. Even now I'm a little emotional. I cried, even though I got the result in my favor. And I cried because there was two deaths, and two others, Jumni and Shamlal, had spent more than 10 years in jail. In between, while the appeal was pending, Premnath and Saroj Bala were granted bail in Supreme Court. With regard to Shamlal, there is a statement that I want to make. He came as a haggard man, entered my office. He said, I've been released from jail, but I don't know whether I should say thank you to you or not. I said, what happened? You should be happy. He said, no. In the jail, I was getting food. I was able to watch TV. What will I do now? Ever since I've come out from jail, I have not had a good meal. I don't know what to do. I have nowhere to go. There is no house left. There was no land in any case. What do I do? Can you give me food? So I did call their family members. They took him back. They must have taken care of them because I never met them thereafter. Now let me talk about the legalities of the case. Now this was case of dying declaration. And before I forget, uh, I'll deal with this case as a whole, because otherwise, like Mahabharat, there can be stories and stories, and they can be legal, one section after section that we can refer in a criminal trial, right from cross-examination to the admissions to the best evidence, all those things. And it certainly requires many more lectures, because trial is something that people don't really learn in their lifetime also at times. That says why there are so many less criminal lawyers compared to any other field. So again, not going too much into it, if if I have to read one judgment on the best trial and to understand a lot of subjects in one trial, that is Sarad Birdichand Sarda versus State of Maharashtra. This was a three-judge bench which heard this case. It was a death sentence case, which was acquitted. The death sentence till High Court. The Supreme Court not only, you know, uh, acquitted the case, but the substance that it dealt with is something that it comes out as one of the best reading. It's like a novel. You will, once you start reading that judgment, you will not put it down. And that is Sarad Birdichand Sarda, 1984 Supreme Court, AIR 1984 Supreme Court. I remember 84 right now. I don't remember the SEC equivalent. 1984 Supreme Court, page 1622, if I'm not mistaken, because I should not be mistaken on this one. There is another judgment if one has to read to understand evidence. Though I may not agree with it, but it was a six-judge bench, 1959. The case was Tehsildar Singh versus State of UP. It deals very comprehensively, and you will see how sensitive the judges were at that time, how much they would like to go into the issues, which unfortunately is not the same today. Nevertheless, let us go back to the case. Now the investigation happened. The background of the case is that these are poor villagers coming from a scheduled caste family. They were so poor that the husband of the deceased and one son that was in Pinjore, he had left and he was barely managing with his family, not sending anything. And then there was this deceased. Again, the only other person who was working in the family was this deceased husband, who was not an accused in this case because he was a Fauji, he was a soldier doing some menial job in, not a soldier on the front. But nevertheless, he was in the Indian army. So he could not have been made an accused. But he made sure that there was a small black and white TV which he could give to his wife and she could watch it. The only possession of hers which was dear to her was this. And Shamlal, the youngest of the brother-in-laws, had a small transistor. So they had a fight. She threw the transistor and transistor broke. In his fit of anger, he broke her television. And it was too much for her to bear. And she committed suicide. She burnt herself. She was taken to the hospital in a burn stage, 100-degree burns, 100% burns, 4-degree burns. She was not to survive, but during her treatment of few hours, the policeman had taken the statement from her, and the magistrate was also called and taken statement. Well, it was later on I realized that the magistrate had never gone inside and taken the statement, but she relied on whatever the case was put by the father or the policeman, whatever was recorded, she appended her signatures. The formalities done was not done by her, by the magistrate. Nevertheless, that was the evidence. And in the trial, except for defense dying declaration, there were no allegations of dowry of nature where they could specify something because they could not have given anything. The girl's family also had no money, which they could have shown that they had given some money. So it was practically a case where there were only allegations like I've given them my best, but these people wanted more, and that is why this has happened. And my daughter was forced to, either they have killed her or she was forced to take this step. So there were alternative charges 302 and 304B because allegations were they killed her or she was to take that steps. The investigation was shoddy despite the bail application mentioning that these people were staying elsewhere. There was no investigation on that. There was no finding on that. But as it happens, irrespective, charge was framed. And the evidence, only 3 witnesses were examined by the prosecution. One was the judge, magistrate. One was the father. One, there were, police witnesses saying these recoveries and this happened, that happened. Yes, one more was one of the villager who had seen, taken her out, and that is all. Other were police witnesses along with the IU. So practically PW7 or PW8 had finished. And there were 7 defense witnesses, as I already stated to you. Now the court examined, relied that yes, there are evidence of plea of alibi that you have taken. But in the wake, that dying declaration is there, and a person who is dying really will not state untruth, and therefore they relied on the dying declaration. Now, dying declaration has to follow a particular procedure, that she in a fit state of mind. Was she really in a state of mind where she could have stated? In this case, there were more than one ground where we could have challenged the dying declaration itself. One, even her fingers were not fit that she could have put her, uh, you know, appended her thumb impressions on her dying declaration. It was her foot that dying declaration was. Two, she had taken morphine injections, and she was not in a state of mind where she could have comprehended such beautifully worded, cohesive FIR. Oh, sorry, statement of what had happened. Three was she was hardly educated to even use those terms and words. Nevertheless, important things that one can do at this stage as a defense counsel is, number one, we have to attack the dying declaration on 3 things. Number one, on the fitness of mind. Number two, on the facts stated in the dying declaration. And three are the technicalities, whether it was asked in as per the High Court rules and orders, whether it was a statement, whether she was asked few questions to see for the magistrate herself that she is in a fit state of mind, instead of relying only on somebody else. The doctor stating that she's in a fit state of mind. Has she also seen her? Did she put some questions to her? Was the dying declaration recorded in question answer form? So all those things were put, and they are important, and most cases should be won if the answers to these are negative. But that does not happen usually. There is a tendency to believe the dying declaration, and that is why I say, read Sarad Birdi Chand Sarda. Not every time one is lucky to be represented by Mr. Ramji Atmani. Not every time one is lucky that bench goes on hearing a matter like this in great details and with great pains. A judgment is written. And you will know what I am saying after you have read the judgment. Besides the dying declaration, another thing that case is perhaps the best judgment on criminal circumstantial evidence. Anyways, coming back to our case. Once there is dying declaration, whatever we could have done, we have done. Then plea of alibi is something that I wanted to talk about. Now, plea of alibi is my only defense. If I have started putting questions that no, I was working there, I'm not here. then if I drop this defense, I have absolutely nothing to fall back on. Then I'm relying either dying, I will swim or sink with the acceptance or denial of dying declaration. But if I have to swim independently, then I have to go on and prove my case of plea of alibi. And with my gut, as a youngster, we went with that plea of alibi defense. Because according to the clients, not only this man was there on both days because he did not come to know about this incident, and they had not even started to go back for the funeral or otherwise, because the first time they realized that something has happened is when the police came to them. So there was something to believe that these people were not there. Now the law is that between the time that something has happened and time that I can come back, that is that if one was in Pinjore, he can go there, that is Jagadri, and if he can come back after committing the offense, and if their time is sufficient, then plea of alibi fails. Now that was perhaps the law existing, and that was the understanding of the judge also. But the argument then was that if the man had gone, will he take his wife for this purpose? He will leave the children, go there and come back. Do they have private conveyance? They could have done a taxi. Now, unless there is a proof that they have done taxi, right or wrong, but if there is an allegation of that sort, then we can examine it. But if there is no proof or even allegation of that nature, then a bus, to go in a bus and then come back in a Haryana government bus, which is dependent upon time, one has to go, catch, then go to a particular distance, go to a village. Again, it would have not been possible within that much of time that I can go commit the crime and come back. The offense had taken place in late afternoon. I was seen in the same in my factory in the evening. I was in the factory next morning. My punched card showed it. I was shown present working on that day. Not only that, the next day, after I had taken half day leave, gone, bought a new scooter, came back, and then worked. And then the police came. Now, there are two aspects to it. One is I could have actually gone and come back. But since there is absolutely nothing to the contrary that there's an allegation of that, then you can't infer. And that was the cardinal mistake that both High Court and Lower Court did. They said because the dying declaration is such a strong piece of evidence and there's a possibility of him committing a crime and come back. So it was not, the plea of alibi was rejected in view of the evidence of dying declaration. Now, it was for the first time that Supreme Court went deep into this. We spent one day only arguing plea of alibi. We argued all various cases on plea of alibi. We also showed the circumstances when the plea of alibi can be rejected. And even though there was not sufficient case law in our favor, we decided to argue the case based fact on fact, as if one frame, another frame transposed on a case. Now, when we started discussing each frame with the court, it became clearer to the court that there is something amiss. Not only that the plea of alibi is a good defense taken, the case itself is a suspect. They started suspecting the dying declaration. But there were two consecutive findings, and it became very difficult for the court then to discard the dying declaration. But in their heart of heart, they perhaps got it that this case is not a truthful case. Remember one thing whenever you read judgments, except for some elaborate judgments, most judgments are the result where judges make up their mind whether they have to allow or dismiss the appeal. And accordingly, some questions are decided. Sometimes, when we read these cases, read some of the case, the case, the circumstances which are doubtful in the background of the result of the case. The acceptance or denial of the defense argument depends upon the conviction of the judge, because no judge wants to do injustice. In his heart and heart, he wants to do justice. So, if he feels, if he, after reading the evidence, that this case is truthful case, maybe there are certain cases, certain things about it which are not true. But yet, if he has made up his mind that this was a case, these people were involved, then the judgment when they write, they will tend to overlook some of the very strong circumstances which otherwise would have favored the accused person. Here, the judges, in this case, in Germany, the judges were sure, or rather, they felt that there has been gross injustice to these people. They were also told how many years they have spent. They were also told how two people have died. And that is why this case resulted into acquittal purely on plea of alibi. And two people, Premnath and his wife Rajbala, were given pure acquittal based on that. Once we are not, there is a doubt on the dying declaration itself, this benefit of doubt has to be given to others also. And so two others also who remained, Jumni and Shamlar, were also acquitted. Now there is a small story, side story to it. Once this case was acquitted, it was a dowry death, and social media and some of the press coverage went wild that a case of dying declaration, case of dowry death, have been acquitted by Supreme Court. Go and see how much of media came. And unfortunately, after so much of bad media, the same bench could not order similar judgments later. And they themselves also perhaps became a little narrow in their approach, conservative in giving relief in these cases. That is a pitfall in criminal cases. One, there is a media buzz that the conviction rate is too low. Two, that you know the defense is too strong, and there are so many other ways that the defense deals with, and therefore there's no justice to the victims of criminal in of a crime. There can be nothing further than truth on this. One, the conviction rate is less because a lot of cases in crime are small cases, which really usually results in compromises. Imagine all 138 case, 498A cases, and so many other property dispute, other personal dispute, which really are not contested in most cases, end up in acquittal, and they are criminal cases. In many other cases, if you strictly go by the evidence, if you go strictly by the uh, you know the rules of accepting criminal trials, that is creating a suspicion, a doubt, the level of the investigations, actually many more cases should be acquitted. But what happens in violent crimes? Suppose there are three injuries, three people are are given those, attributed those injuries, as if one would only give one injury, come back, invite the other to create another one. And while I was in Chandigarh, as such, there were not too many white collar crimes at that time, except for some PC Act cases and some others. As we have seen today, here is the white collar practice. In those days, it was primarily the violent crimes. Criminal lawyers would only do division bench cases, the best criminal lawyers, which meant murder cases or any cases which more than 10 years of sentence. All single bench cases would be done by juniors. I was lucky, I was a junior at that time. I did a lot of cases which are helping me today. Did few murder cases at that time. I got my chance to do my murder cases later. But the lack of good evidence which can be collected, or let us say you will have few judgments talking about scientific evidence. Scientific evidence is not a term which started now. From 80s onward, there was a lot of tools which could have aided in scientific investigation. They were rarely been used. Even today, just to complete. So in those days, if there were 17 injuries, usually there used to be 8, 9 or more than that people who were accused. Then, if it was a murder case, the most influential person of the family, if he was there, would be given the fatal blow. It does not matter who has actually given the fatal blow, but the attribution would be to the most influential family, because the victim's family wanted to destroy the accused family. It was not merely getting justice as to who has done. It was also revenge. And therefore, many a times a judge then would realize that these are not the persons involved. And if it was too blatant, the acquittal was on the cards. And good judges in those days were also who could sense that these are four witnesses, four accused who are not involved. And many a times they would ask the lawyer, we will give 304 in these cases for these people, and tell me which of the person you think you should be who were not there, because clearly there were only four people, and these are 7 8 accused. You convince us from the evidence which are those three people, and a lawyer then would spend some time trying to tell the judge which three people are perhaps not there, and the judge would believe some lawyers blindly and some with a pinch of salt after looking at the evidence, and would actually give benefit of doubt to those people. Again, if you really see, did not depend too much on the quality of evidence. It was on the gut of the judge. And that is what many a times we miss these days, is those judges with those gut who would say that there is something amiss. There is more people who are involved than there should have been. But many times in our times we have seen the judges either discard the whole case or accept the whole case. And there is very little sifting that is done. There are cases where the judges still sift. The number of accused is high, but but that is rare. In most cases, in a trial, the judge don't do it. Now, this is, I thought I'll take you to a journey of one of my cases where I would tell you the defense taken by me, which is critical in the trial. The art of cross examination and other things, we have already had a lecture. I believe I will ask the hosts to put that a link somewhere on the uh, chat box, or maybe with the link with the YouTube video or whatever, wherever possible. I don't know much about that, but that link will be there. I also thought that with regard to what is permitted
Sir,
as
definitely will.
evidence, what is permitted, yes,
Sure, sir.
very well. So, so just let me complete. Give me another 5 10 minutes. Let me complete.
Sure, sir. We'll definitely put that link in our comment section.
Very well. Just allow me 10 minutes, 5 10 minutes more. I'll let me complete. So, uh, friends, there are three things that one should, three or four things that one should focus on
Sure,
in
sir.
a trial,
Please continue.
and few things that one should concentrate in a trial is: one, read your charge sheet as many times. Make a chart on the board. Make a pictorial. Suppose it's a violent crime, then injuries. Make a chart of a human being. Injuries. Then what injury from which particular weapon, attributed to whom, what is he. Make a character chart of each accused, each witness. Try to create a crime scene on a piece of paper. There's a field, draw a field. Who was standing where? You know whether one can watch from there or not. There are cases where the eyewitness can be, discredited only because he is not able to see the crime or the occurrence from where he was standing. Also, then the background of the families, whether there is an occasion to wrongly, involve somebody, create it on this on a piece of paper, everything, the crime scene, character. The hard work is to be done before the trial has to start. Whatever you have to read on medical jurisprudence, read Modi, read Cox, read others. For all I know, my favorite was HMV Cox and Modi. Now there are so many more. Read the judgments of the defense that you are likely to take. Go into the phrases used in those judgments, which should be part of your questions that you have to put to the witnesses. See that question, answer come accordingly. And in criminal law, ask a question which you are definite that this can be the only reply, and if this is not the reply, then it has to be false. And you can prove that to be a false, and then discredit the witness. If you ask something from a witness of which you don't know the reply, and you are fishing in the dark, then you are taking a chance. You can hit a jackpot, but you may not. There is a case that I am still doing, where the allegations were that the person, the accused, strangled the victim and then threw the body somewhere. Yet, in the post-mortem report, there were injuries. Now, both things are not possible. If someone was strangled and then thrown, then if there are injuries as a result of fall, then only one thing has to be true. Either injuries were as per the fall, or it were strangled and then when thrown, it has to be a post-mortem injury. It can't be an ante-mortem injury. In this case, there were ante-mortem injuries. But yet, to ask a doctor this question, it required courage. Because had he cleared it, then I have no other case. But here, there is no certainty as to how a doctor would behave. Because even if he would have written truth, the public prosecutor and the IO would tell him as to what to do. So in his entire cross-examination, we were only fishing how much he has been tutored. So all questions that were put to him were also, although based on the evidence, but very guarded. Again, we knew the answers to it was only certain. But this question, when we are hard to convince that he is not tutored, we slipped in this question. Whether these injuries are ante-mortem, he said yes. I said then if these injuries are possible if somebody wants to commits suicide, he jumps. He said yes. And then it was all over. And although in this case the prosecution moved an application and changed the contents of the charge, quick to do that. But what I'm telling you is that these kind of risks are to be taken when you are 90% sure, not 10% you have to. But these are also in when you have nothing else, when this is the crux of your defense. Otherwise, there has to be a definite answer. If I ask your name, he has to say, my name is Ram Singh, if I am asking a question to Ram Singh. I said, oh, you do this, and I must know he does a particular work. Let's say he's a mason. Then he has to say, yes, I am a mason. I am a resident of this village. Were you present there? I don't have to ask that. If he says, yes, I am present, my case is gone. I have to then ask him questions on the basis of what we have seen. I have to prove without asking this question that he was not present at the spot. Did you see this? He will say, no. Did you see this? Did this happen? Because that is not there. Based on the other evidence, based on this crime scene. I have to discredit him without asking whether you were present. Because asking that question whether you were present and he says, yes, I was present, my case is done. I have myself ruined my case. So ask a question which you are definite that this is the only reply. Don't fish in a criminal trial. Again, just to conclude, read your charge sheet again and again, make charts, character sketches of all witnesses, put some questions, what he is going to say, why he was there, why has been he put into this witness box, what he can say, all those W, whichever is applicable, put those questions to yourself first in on your table, working table, and then select what you need to ask. Make a chart, questions, but never make all questions in a way that if you have to change based on his reply. Now, why is it possible? Sometimes you write 10 questions. Does not mean you have to ask those 10 questions. You may have omit some based on what he has said. You may have to add 30 more right there and then based on what he has said. Now, how will you put it? Only when you know the entire background, the character sketch, the crime scene. And if you're a trial lawyer, go and see the crime scene. You will find so many questions. In 1984 riots, I went 3 days as a prosecutor to that place where the entire thing had happened. I walked the entire thing. I tried to, first I had read the charge sheet. I tried to see running through those lanes. Can I not? I went and asked the people, various people I interviewed. I saw there was a scare even after 30 years. Even people are not ready to say anything. And that helped me to fight my case. So, defense lawyer, you have to go under the skin in a trial court of the case. It is not like High Court or Supreme Court that you have prepared and you've gone and argued. It is not so much about law. You must know the principles of law. Because how will you object to certain questions? How will you keep your questions within the domain of law? That is necessary. But discrediting a witness is an art. But that art also needs prerequisites. And those prerequisites are deep understanding of human character, sociology of people, their background, why they would say so, why they would act in a particular manner. Study of anthropology or understanding of anthropology is important. Understanding of communities is important. Understanding of the background of the person is important. Understanding the culture of that place is important. Traditions of that place is important. The place of occurrence is it will give you a lot of clues what to argue, what to ask, what not to ask. All that forms is a part and parcel of trial strategy and forms the strategy for a trial. And thereafter, you will be able to contest your trial, defend it or prosecute it, whatever it is. If you undergo the entire process, as I had stated, you'll make a fabulous lawyer. Before I go, though that was one instance of mine where I had gone and done this trial, it was pure fluke, hard work, that I achieved my success too late in this case after 15, 16 years in Supreme Court. But my second good lesson was learnt. I was still in the High Court. And then the entire family of Relu Ram, who was an MLA, he, his wife, son, daughter, grandson, grandchildren, not one, two of them, 1 year in this, and one more. 7 murders had happened. And the allegation was on one of the daughters and her husband. You can go on the net and find it. And an application was moved that the police has not done a good job, police has done this, police has moved this. We want a CBI investigation. And certainly there was a ploy to take it to the CBI application. One was to delay the entire thing and two to derail. I was in the Advocate General's office and judge said, why should I not send it to CBI? It's such a gruesome case and you have hardly done a good job. I said, my lord, I can argue this, but you give me 3 days time. He said, okay. I still remember Justice V.M. Jain was the judge. And 3 days was because there was a Saturday, Sunday in between. I went to Hisar. I called the Superintendent of Police and they took me to the site. We spent 4 hours looking at the house again and again and again and again, reenacting how two people can go to different rooms. People were in different places. How can two people commit this crime? There were servants. There were people sleeping in different rooms. It's not possible, perhaps. This is what the judge also felt. And after going through the entire thing, then I got convinced because they showed me how they came, how it happened. It was reenacted by the police for me. Then we started arguing. It was, you should take at 2 o'clock. And for 17 days, this case was argued. And the test was that judge said, convince me that you can prosecute this case with success. So we first succeeded it in the High Court only on the basis of the charge sheet. After 17 days of hard work, we convinced the judge that this is the case and these are two other actual accused. And that stood the test. They were convicted later on. The conviction was maintained by High Court and also by the Supreme Court. There was death sentence from all courts, but I believe in the Supreme Court, it was because of the time that it had taken. It was reduced to a life sentence and were converted to a life sentence. I'm sorry that I did not go to the extensive nitty-gritties of each frame, how the prosecution would have happened, how questions could have been put, the objections that can be taken by a defense counsel, the admissions, the importance of certain statements, but God willing, in better times, we might get another chance to deal only with a criminal trial in that manner and do it more extensively. As of now, if there are any questions, I will answer it, or else that's all from my side. Thank you very much.
Now, I would like to thank Sir for enlightening us with his wise words, and thanks a lot, Sir. And if
Well,
there would be any questions, we'll definitely forward it to you, Sir.
thank you.
Thank you.